organized by the Family and Succession Law Special Interest Group of the European Law Institute. And welcome to this webinar. So I was saying, this webinar is relating to the new family law, that is the specifically, namely about children in law and new family models. About that, so we are having two sections or sessions. The first one on children in new family law, and after a brief break, a second session about new family models. The first one will be chaired by my colleague Elena Bargelli, who is professor at the University of Pisa, and he is also co-chair of the SID. And the second one will be chaired by my colleague Ilaria Petrelli, who is our researcher at the Swiss Institute of Comparative Law, and she's also the co-chair of the SID at the ELI. Well, first of all, I'm Francisco Javier Jiménez Muñoz. I'm one of the three co-chairs of the SID on family and succession law of the ELI. I'm also a professor at the Spanish University, UNED, where I'm also the head of the master degree on family and succession law, and the secretary of an institute of research on family and succession law. So these institutions are also involved in the organization of this webinar. So, well, I'm not going to expand my presentation more, and I give the floor to my colleague Elena Bargelli, who, as I have told you, is going to be the chair of the session first. So, Elena. So, un attimo, one moment. Technical problems. I think, yes. So, yes, I think you can switch on your microphone. Oh, sorry. This is, one moment. Uh-huh. Yeah, and you have the
Okay, can you hear me?
Yes. Yes. Yes.
Okay, thank you very much,
Sorry.
Francisco. Unfortunately, I can't open the webcam. It is not allowed to me, but perhaps my voice is enough. Well, first of all, I would like to welcome all the participants to this webinar, which is the last one of the year 2023. The last ones organized by the Family and Succession Law Special Interest Group. I would like to thank Francisco for organizing this conference, which is quite in line. Okay, now I can switch on my webcam. Okay, thank you very much, Francisco.
No.
I was telling that I would like to thank Francisco for organizing this webinar, this promising webinar, which is quite in line with the topics the SIG has dealt with during this year, during the current year. I don't want to. I would like to spare time, and therefore I immediately give the floor to Virginia Zambrano, who is a full professor of comparative private law at the University of Salerno, Italy. Please, Virginia, the floor is yours.
Virginia.
Perhaps she has the same technical problems as I had.
Let's see.
Yeah.
Virginia.
Well, Virginia will
now
open the session dedicated to children in new family law and will deal with the competition between legal systems and the harmonization of family law in Europe. I can't hear.
No,
We
Virginia.
hear you, Virginia. We
Yes.
hear you. Perhaps you can't hear us.
That I don't know because the. Oh. Yes. Well.
Can you hear?
Yes.
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 Okay.
Yes.
Now, yes.
Yes.
Now I do. Okay. Okay. Good morning. Ciao. So, how are you?
Well, fine. Thank you, Virginia. Thank you very much. The floor is yours, and sorry for these technical problems.
No. You are welcome. Francisco has already said something?
Yeah. Yes. Go
so
on.
I can start. Well, first of all, thanks to everybody. So happy to be here with you this morning, and so happy of talking about the competition, or let me say, what I suppose what many people suppose is competition between legal systems. Now I want to start just by quoting Tolstoy in Anna Karenina. And Tolstoy said, all happy families are similar. Every unhappy family is unhappy in its own way. Thus, to emphasize both the equality of family problems, but also the differences in family relationship. When looking at family relationship, one lesson is obvious. Family law systems are profoundly influenced by religious, cultural factors, and so differences in Europe and all around the world are only to be expected. This is of significance when talking about competition between legal systems and the harmonization and standardization of legal rules. Hardly can we imagine in family law matter a higher level of harmonization. Furthermore, the European Union does not, as yet, have a specific competence to approve binding legislative act, a competence that, as the judge in the Bundesverfassungsgericht of some years ago, 2009, said, of course, cannot be transferred, this competence, to the European Union because it would lead to a violation of state sovereignty. Despite the differences between the various different legal systems, however, some reflection seems to be necessary. On the one hand, there is the need to verify within the European framework how the recognition of family-based emotional ties has overturned and changed the classical model of marital consortium, paving the way for the birth, let me say, of new rights. On the other hand, by investigating among the general principles contained in the national constitution, the general principle non-constitutional for source, which, however, contribute to shaping the system, the principle of transnational sources enshrined in the agreement between states. Well, on the other hand, it seems all this considered essential to scrutinize the forces at work. And now this process takes place, of course. Now, what we are talking about in a perspective of social engineering and policy of the law is whether or not it's possible to identify in family law matter a harmonization process achieved as a result of the application of a legal rule perceived as more reasonable or more efficient. I do not claim this is the case. To me, it's more a question of identifying the parameters for rearranging the traditional dogmatic categories by looking at the heterogeneous principles that sign the evolution of family law. In this sense, it seems to me that rather than looking at the identification of the most suitable, appropriate rule, it's more a question of verifying how the dialogue between legal formats is being carried out. A few examples will help me to better explain my point. Let us start with the family concept. There is a substantial impossibility of finding a comprehensive definition of it. It is true that constitution principles have a profound impact on the development of family law, and that modern constitutions are all right-oriented. But we can, and we of course are aware of that, we can't stop the constitutional principle. It is also true that these high-ranking values, which express the founding values of a community, comes to terms with issue of legal policy and question of interpretation and application of legal rule. More, European constitutions do not always leave room for the concept of family or offer even a definition of what family is or look like. Of course, Italy, Portugal, Ireland, Greece, just to name few, adopt this approach. But no direct constitutional reference is found, on the contrary, in Austria, for instance, whose Article 10 refers the civil law regulation to the federal jurisdiction, or in Belgium, Spain, Luxembourg, Netherlands, Sweden, where the matter remains entirely governed by civil law. The concept of family does not have, then, a distinctive legal identity as compared to the life of its member. Therefore, instead of using the term family, one should speak of family life as enshrined in the European Convention of Human Rights and in the Charter of the Fundamental Rights of the European Union. The family, in few words, is not reduced to what national law defines as family. The Strasbourg judges are well aware of this and have developed a particularly rich case law on family life as an individual right, not on the family as an objective entity. The only holder of the subjective right to family life is the person, the individual. Nor can the harmonizing force of the European regulation be denied. This regulation is addressing some crucial choices about divorce, marriage, property regime, regulation whose indirect effect is to shape a common vision of what family law is or look like. However, it's undeniable that European case law acts as an engine, motor, to create a condition for a shared conception of what is to be considered a family. The European Court of Human Rights, in the Eschholz case, emphasized that family life is not limited to relationship based on marriage. It can include other de facto relationships in which people live outside of marriage. And a married woman and man, and a married woman and her daughter constitute a family life, as do an unmarried man and his daughter, or the living together of two sisters. By developing a situation-oriented analysis of the factual affective relationship, European judges have so contributed to the creation of a certain number of rules independently from the various national laws. The Conan versus Romania case illustrates very well what I am saying. In a ruling issued against Romania in 2019, the judge of the European Court of Human Rights stated that if a homosexual European migrant marries in a country that admits same-sex marriage, he must be then entitled to the same rights better as opposite-sex spouses across the Europe. In Coman versus Romania, the couple, which had lived and married in Belgium, had then moved to Romania, where authorities didn't issue to Hamilton, Coman's husband, a resident permit on the ground that Romanian law does not allow same-sex marriage and does not recognize foreign same-sex marriage. For the judge, the term spouse included any part to a marriage lawfully celebrated in a member state. Because Hamilton had married Conan in Belgium, they were spouses under the European law of free movement of persons. Now, the court's ruling was, in my opinion, a thoughtful one. Rejecting Coman's case could give an advantage to those legal systems where same-sex marriage is not recognized, a kind of opportunity also to challenge the recognition of other member states' civil status decision on the broader question of marriage, divorce, and parentage. To avoid this effect, the court explicitly recognized that the judgment does not require Romania to introduce same-sex marriage. Romania was simply required to recognize, in application of the right to free movement, marriages lawfully celebrated in other European countries, which means to make a long story short, that same-sex couples living in countries not allowing same-sex marriage, and there are 14, I think, and a lot, are entitled to enjoy all the legal rights guaranteed by European law. To hold that Romania could refuse to recognize a Belgian marriage would have undermined the democratic choice of half Europe. The other half country may continue to refuse to allow same-sex couples to marry there, but they cannot stop citizens including their own, from enjoying all the legal rights guaranteed by European law. The Coleman and Hamilton judgment is solidly based in the language of European law and European policies of respecting the national tradition of each member state. But the effect it produces is not worthy and tell us that the long struggle for the recognition of the right to marry for same-sex couples is not only exemplified by hostility against homosexuality or concern for the right of minors, but also, and to me it's quite significant, and above all, as an opposition to the complete, this is the point, in my opinion, contractualization of the marriage, in which the difference between the sexes is going progressively to lose its relevance. Proof of it in Italy, where in a ruling of the judge of the Supreme Court of Cassazione 2015, the judge emphasized that heterosexuality had lost its paradigmatic meaning, allowing in a case of sex rectification of a spouse, whereas both spouses had expressed the will to maintain the couple's bond, well, the automatic establishment of a civil union between persons of the same sex. And on this topic, there is pending in front of the Constitutional Court a question of constitutionality by the court of the tribunal, the Lucca Tribunal. Sure, France had already come to this solution with in 2013 with the law on le mariage pour tous, but not without going first through a very remote decision of the Cour d'Appel de Paris dating back to 1998, in which it was observed that espoused homosexuality was such a serious breach of the obligation arising from marriage that, of course, to the point to render, let me say, to render life together unacceptable. The Italian decision of the 2015, in this sense, rather than being a product of the circulation of a model perceived as more reasonable, more acceptable, stems from the consideration of a series of elements that, coming directly from social reality, are vested with a high level of normativity. The first evidence of this change can be traced back to some distant judgment. I am referring to a judgment of the Constitutional Court of 2010. There, the question of constitutionality was based on the fact that Article 87 on the matrimonial impediments makes no reference to persons of the same sex. For the applicants, in order to avoid unjustified discrimination, it would have been sufficient to replace the expression husband and wife with the term spouse, as the Spanish do. But for the judges, the core of the institution was still heterosexuality. However, looking also at the European experience, they launched an important, I use a football jargon, an important access to the legislator that in 2016 will give birth, will conceive the Cirinna law. What comes out? When looking retrospectively at what was happening in Italy and in France, one realized how the judges, by observing the new social reality, have attempted to offer the lawmaker an exhaustive picture of the threats that, in terms of pluralism of family models, are accompanying the family's evolution. This is where the call for change comes from. In both cases, if one look both at the path that led to the marriage pour two in France and at the Italian experience. What is evident to me is the resistance, just scraping a little bit the surface, is the resistance of the legal system to accept that private autonomy, by entering the field of family relation, compromise the institutional vision of the family. When faced with this fear, the legal system raised their own defense. Thus, for example, on the subject of medical assisted reproduction. Well, the Italian constitutional judge, in a case recently, May of this year, in a case of consent withdrawal, but the husband, after the envisaged deadline, do not follow the path in the Evans versus United Kingdom case, departing from the rule that operate in England, Austria, and France, where the withdrawal of consent is possible until the embryo is implanted. In doing so, the judges apply the wide margin of appreciation doctrine as inferred from Article 8 of the European Charter and so on and so on. But Italian judges do something else too. What they do, they carefully read Evans and, to strengthen their argument, use a passage in which the European judges express their, and I am quoting a passage of the sentence, great sympathy for the applicant who clearly, which is in Evans, this sentence, who clearly desire a genetic related child above all. Why they do that? They do that to infer that not even the European judges were ultimately happy with their decision. But of course, it is an interpretative escamotage, because they also point out that the Italian legislator should regulate the case in a different way. The use of private autonomy in the sphere of family relation, in short, frightens. This is especially true when involves the construction of the vertical relationship. Here the answer is at least formally negative. The same is also true for, of course, surrogate motherhood. The judge recently, last year, the judge of our Court of Cassazione have finally settled the question of a birth certificate transcription draft abroad. They state that the non-biological parent relationship cannot be recognized. In the background of this decision, we have Menesson versus France, Ladacé versus France, Paradiso and Campanelli, and so on, and so on, and so on. The Italian judge's decision was certainly influenced by the case law of the European Court of Human Rights that goes in the direction of the recognition of the legal bond between the son and his biological father. But for European judges having to deal with different legal framework, it's also possible, regarding the position of the intentional parent and, of course, respecting the best interests of the child, to opt for alternative means, such as adoption, as formalized in the first advisory opinion of the Grand Chambre of 2019. The message coming from the European judges is clear. When the best interest of the child is at stake, this should prevail, limiting legislative discretion. But the tipping point of the discourse is nevertheless portrayed by the public order barrier, a barrier that operates also in the meaningful ruling, or in a meaningful ruling of the European Court of Human Rights on the parental status of a transgender female parent who asked, that's April of this year, who asked the German authorities to register her as father in the child's birth certificate. The judge denied. Why? The public order barrier in spite of the progressive integration between jurisdiction, is erected to protect the identity of each legal system and represent a value with some degree of precedence even over the interest of the child. Of course, the child's interest in the establishment of the parent-child relationship is an undisputed profile, but the intention of the party is always subject to a careful scrutiny, especially when it appears to alter the naturalness of the constitution of parent-child relationship. Yet, evidence of this growing space of private autonomy is the discipline of divorce. In France, the law 2016 introduced the divorce by agreement, a completely privatized procedure depending on the party's sole will, without intervention of a judge. The new divorce is completely out of court and is exclusively governed by the common law of a contract. Similarly, at a procedural level, procedural level where privatization seems to be progressively achieved. The same for the Portuguese experience or the Spanish one. In this direction, also the Italian system is moving. In a very recent decision of this October of the Supreme Court of Cassatione, the judge seemed to give room for private autonomy in divorce proceeding. On the ground of Article 473 bis of the Civil Procedure Code, they have recognized the possibility for the parties to file a joint application for separation and divorce. Faced with an Italian law which has shaped a two-step dissolution of the marriage, separation and divorce, has appeared a case law that, in view of the need for a quick time to divorce and interpreting the evolving social cultural climate, has in fact addressed an invitation to the Italian legislator to come up with a more efficient discipline. The judges in this way show that they are in support of a favor libertatis principle, enhancing the autonomy of the spouses. Italian judges get there not following a particular model or a system that could offer a more efficient rule. End of the story, with the concluding remark that it is extremely difficult to find out a common root, not for sure. Actually, we cannot forget the role, which is, I find it's, of course, important, played by European private law, international private law, which has also a scope of modernization of the traditional categories of domestic law. The aim is to bring out different and alternative principles without formally affecting the values that constitute the heritage of a legal system. The strength of this soft law approach lies precisely in its weakness. The development of guiding principles, let's think to regulation on the recognition of decision in family matter, to the two recent regulation 2016 on matrimonial property regime and on registered partnership property regime, deprives of the law's authority, allow the circulation of this principle, provided they are able to meet the real needs of the international community, that they are really competitive. Here, the intention of harmonizing the rules of conflict that have a direct impact on the function of the market is evident. The parties are left free to decide whether or not to resort to the intentionally provided matrimonial property rules. Therefore, it is up to private autonomy choosing which is the most efficient rule and to determine accordingly Accordingly, the adaptation of the national law is the private autonomy, therefore, that appear to contribute to the competition between models and different systems, producing as side effect the alignment of the national family law on matters having a direct impact on the market. That is to say that the method of dialogue, competition, cooperation, normative differentiation introduced with the season of regulation of private and procedural international law seems to be a winning one, since by allowing the parties to choose the applicable law and the competent court leads to the identification of the model and solution that are felt, perceived as the most efficient and functional to the needs, to satisfy the needs and the interest of the party. The bottom-up approach, or if you wish, the consent approach, is determining the identification, in this case, of the better rule. On the other side, in case of litigation, the activity of the court would function as an instrument of integration and interpretation of the rule and choices made by the party, and then operates as a tool of integration. The two-way circulation of models from practice regulated by private autonomy to national courts, from the national courts to the European courts, and from this again to the national courts and to the practice of legal system, in many ways offer a more significant path to harmonization than that promoted by institutional, legislative, or doctrinal legislative instrument alone. And I am hoping I respected the time. As far as family law is concerned, it seems to me that the competition between the rules operates at the level of each legal system. It is a simple question of selecting the most efficient rule through the development, sometimes, of a competitive interpretative technique, a competition enhanced by the economic and cultural integration process that should lead to the emergence of a common future substratum over which the hermeneutical activity of the European Court and national judges could be successfully grafted. Thank you. And I hope to have been respectful of the time.
Thank you very much, Virginia. Thank you very much for your comprehensive overview of the new family law, which is a wonderful introduction to more specific topics which will be dealt with by the other speakers of the morning. And therefore, I am giving now the floor to Roberta Marino, who is a private law professor at the University of Naples, Federico II, and who will speak. The title of her presentation will be Equality Between Parents and the Attribution of Surnames to Children. Please, Roberta, the floor is yours.
Thank you, Professor Bargelli. Let me thank even Professor Francisco Javier Jimenez Munoz for this invitation. I'm very honored to be here. First of all, I want to say that the question relating to the attribution of the surnames of both parents to their children has for a long time been the subject of interest in doctrine and jurisprudence. The surname, together with the name, represent the core of the legal and social identity of the person, which allows their identificability both in public and in private law relationships. Surname is therefore the identity that connects the individual to social formation. Unlike the first name, the surname is also an element that characterizes the individual in the social context, because it expresses the identity of the person in terms of lineage, I mean a biological or emotional lineage. The surname, therefore, is a suitable tool not only to identify a given person, but also to link a specific identity to him, so that it must be attributed taking into account the fact that each individual descends for a specific pair of parents. So it can be said that every person has the right not just to have any surname, but that surname which testifies the bond with both parents. We can simply explain the mechanism of the acquisition of the surname by the child in 3 different systems, and the 4th one is the combining of the three systems. The first is a principle of prevalence. The second is a principle of equality with prevalence. The spouses have the right to choose one or their respective surnames to represent the family unit. The third is a principle of equality without prevalence, double surname mechanism. The family of origin surname is maintained alongside at the time of marriage. The fourth, these 3 systems can be contained in various ways with each other, as well as complicated by the possible acquisition of a new surname by the spouse. I want to point that in the case of application of the equality principle without prevalence, this equality between spouses leads to the automatic attribution of a double surname to the children. And to avoid the exponential increase of surname, only the first of the surname of each parent should be attributed to the offspring. In analyzing the problems relating to the regulation of the surname, it emerged the need of a correct balance between the child's right to identity and the equality of parents. The unity of the family, in fact, is realized and completed by the equality of its members, so that the disparity in treatment between parents in terms of the attribution of the surname of their children is contrary to the principle of equality according to all European constitutions. The attribution of the only father's surname to children seems to me not to be justified on the basis of family unit, since the unity of family could be equally safeguarded by attributing the maternal surname of the joint surname of both parents. The legislator intention, to protect the principle of family unity with the automatism of the patronymic is no more in step with the evolution of the concept of family. In fact, for some times now, there has been a destructuring, as Professor Zambrano said, of the family as an institution, by virtue of the change in social conscience. Moreover, the freedom to carry out the separation with the relative simplification of the procedures in many countries, is it now true, highlights how today's family model is opposed to the institutional one, because it is characterized by a growing recognition of autonomy and therefore of the value attributed to individual rights. In light of these developments, both in relationship between spouses as well as between parents and children, and in the social dimension of our new family, the constitutional recognized rank of gender equality and fundamental human rights, value now consecrated at an international level, make the automatic attribution of the patronymic anachronistic, and the related controversy between conservative orientation and progressive orientation becomes the elective forum in which claim the right to identity and self-determination. Now, I would like to point that in the New York Convention contains the provision at the Article 17, letter G, letter G, which provides for the duty of states to ensure the same personal rights for husband and wife, including the choice of surname. At the community level, it should be remembered that Council of Europe resolution number 37 of 1978 and recommendation of European Parliament 1271 of 1995 and 3072 of 1998, in which Council and European Parliament note that the persistence of discriminatory rule between men and women on the attribution of the family name determines a violation of the equality principle. Especially over the last 2 decades, many countries in continental Europe have undergone fundamental reforms of the rules relating to the transmission of the surname to children under the pressure of the principle of equality between men and women and non-disparity in treatment based on the type of filiation. This has led to the erosion of the whisperhead principle, prescribing the automatic and invariable attribution of the descendants of the paternal surname and the finally recognition of the possibility for them to be attributed mother's surname. Now my analysis will focus on European country law system, then touch upon experience such as those Nordic countries and England, marked by a generally less conservative approach. I will finally conclude with a little survey on the Italian situation. First of all, I want to mark that gender equality is a topic that has affected the legislation of Western European countries, which have adopted different solutions, which highlights the dissimilar interpretation of the family unity principle. The problem, in fact, belongs to the right balance, as I said, between concept of family unit and the principle of equality of spouses, and therefore in the appropriate evaluation of whether the former should be understood as a legitimate limit for the latter, or whether it can be combined in a single solution that guarantees both. We are therefore witnessing a modulation of the rules for some, for name, and the consequent elaboration of the individual's identity criterion. I would like to underline that in Western legal system, the trend is toward abandoning the rule adopted today regarding the transmission of the patronymic to children. In Germany, the principle of unity has always prevailed, whereby marriage is understood as the fusion between two subjects in a new family unit, for which the spouses, by mutual agreement, chose the surname of one of the two or both in the preferred order. With the reform of 1993, however, the egalitarian concept between spouses was strengthened, whereby if a family surname is not chosen, each of the spouses will keep their own surname, differently from what happened in the past, whereas in lack of a specific indication, the patronymic prevailed. In France, at the beginning, the spouses, without losing the surname of origin, could choose to add the so-called nom d'usage. After, with law on March 2002 or 304, number 304, the possibility was recognized for spouses to pass on one of the two surnames or a double surname to their children. In the absence, however, of a joint declaration by the spouses, the child is given the father's surname. Even in Spain, spouses maintain their original surname, a rule, you know, initially whispered by custom and then required by law. The Article 109 of Código Civil, modified by Law number 40 of 1999, consecrated the principle of double surname, providing that the first surname of the father and the first surname of the mother are transmitted to the children with the choice of the order to be followed then for all the offspring, and with the possibility for the son, once he reached the age of majority, to ask for the order of his surnames to be changed. In this way, however, the patrilineal system was followed up, since only the first name of each person passed from generation to generation. In the year 211, the legislator intervened again to simplify the procedure for reversing the order of surname, which today consists of a mere declaration of will by the interested party to the person in charge of civil register. The change will come into force after into 217, provided lastly that if the parent is not established the order of the surname and there's no agreement between them, after the 3-day period, the civil register officer will have to establish it following the principle of the best interest of the child. In Portugal, according to civil code, the child is entitled to the surnames of the father and mother, or only one, depending on the choice of the parents. In case of a disagreement, the decision will be left to the judge, who will evaluate it basing on the principle of best interest of the child. In most legal systems of American inspiration, however, individual freedom prevails over the family unit, and so at the time of birth, the mother or parents, by mutual agreement, generally choose one of the following as their child's surname. Them or both, also having the possibility of combining them in a creative way or choosing a fictional surname, provided that it not cause confusion, harm the rights of others, or cause social sensitivity. The surname can be different for each child of the couple, with the possibility of change. The law of the Nordic countries and English law has always looked at the question of transmitting the surname to children from a different perspective. The former are even characterized by a certain favor towards the transmission of the maternal name to future generations. If it is in fact true that in Denmark, Sweden, and Finland, children take the common surname chosen by the parents to distinguish their union, or alternatively, the surname of the one between the two that have the joint design. In the absence of choice, the son acquires his mother's surname. The same rule applied to natural filiation, we know. Unlike that, what happens today in many European countries, in the Scandinavian area, it is therefore not possible to acquire a double surname, although the choice to assign the child, we can choose a middle surname. On this point, however, a recent development that has affected Sweden should be noted as a part of a border reform aimed to strengthen the individual power of self-determination regarding his own name. It is now possible for the newly born to also choose a double surname. In England, the choice and change of surname has always been allowed by a certain breadth compared to continental Europe, and although since the 18th century there has been a widespread affirmation of the evolution according to patrilineal criterion, this has never resulted in a rule imposed by law. Thus, when registering a birth, the child can not only take the father's surname, but alternative, the mother's surname of both parents, or even, although it's rather uncommon, a different surname. In the case of disagreement between parents, the judge decides. Let's come at least to the Italian legal system. Here, the automatic attribution of the father's surname established by our system has posed a problem of compatibility with the constitutional principle of equality of spouses and parents, established and stressed in the Article 3 and in the Article 29, paragraph 2 of our Constitution. To this day, Italy has preserved the automatism of the patronymic in homage to the principle of family unit referred to Article 29, paragraph 2, which established the moral and social equality of spouses. Although the main objective of the reform of 1975 was the elimination of the disparity in position between spouses contained in many provisions of our civil code, equality between spouses was not fully achieved. In Italy, you know, the discipline of transmitting the surname to children has been waiting for years for a reform that fully implements the constitutional principles and finally takes into account the changes that have occurred in collective sensitivity and values. Over the years, the copious jurisprudence regarding the attribution of the surname has expressed orientation aimed at progressively corroding the intangible rule of attributing the father's surname to the child. The automatism of the patronymic, therefore, is not only in conflict with the principle of equality of parents, but would undermine the right to identity protected by our Article 2 of Constitution. Recently, the Constitutional Court expresses its opinion with a sentence 131 of 2022, declaring the constitutional illegitimacy of the Article 272, paragraph 1 of our Civil Code. This provision, says the court, in addition to violating the principle of equality of parents, would also be detrimental to the minor's right to identity, denying him the possibility of being identified from birth, even with his maternal surname. As we know, our legislature for years has done many bills, followed one another with constant regularity. But now, in light to the fact produced by court's ruling, legislative intervention has become necessary, aimed at resolving certain application issues. First of all, as mentioned, in the succession of generation, a multiplayer mechanism could be created, which would be detrimental to the identify function of the surname. Secondly, having regard for the homogeneity of the surname for the offspring, in the absence of a specific discipline, there would be the risk of assigning a different surname to brothers and sisters in defiance to the principle of family unity. We know the legislator is looking for the Spanish system. There's a project of law that has been approved in our parliament. However, to conclude, I believe that if you look at our legal system, the discipline with which to regulate the double surname system is already present, although with specific reference to civil unions. In fact, I think that the Italian legislator could simply adopt a different solution, that on intervention aiding and modifying the Article 143 bis of the Civil Code, in the sense that, as for the parties of civil unions, even in the case of marriage, the spouses could choose which are their names to take as common to be placed before or after the other. Thank you for your attention.
Thank you very much. The next presentation will focus on one of the most significant aspects of children law, which is guardianship. I give the floor to Maria Dolores Casas Planes, who is professor of civil law at the University of Jaén. I hope that the pronunciation is correct. And since we are running late, I kindly recommend to respect the time limit. Thank you very much. And please, Maria Dolores, the floor is yours.
Thank you so much. Good morning to all of you. Sorry for the voices for my cold. So firstly, I don't know if it's possible to share a presentation because is possible because I have not.
Well, if you have a PowerPoint presentation, it is highly appreciated, but I don't know how to share usually because I'm not the manager. But if you
the manager must allow me. It's only 1 minute, so I just start to talk. So I would like, in order to respect it, I would like to start by by expressing my gratitude to all the organizers of this webinar, the European Law Institute, and so IDAFE, and mainly to Francisco Jimenez. It is really an honor for me. And so thank you so much for all people who are listening right now. And so the topic I'm going to address, I don't know if it's possible to, because I have all the presentation.
Well,
if not,
can you press the button at
yes,
the
but
right
it's not allowed. It's not
active. It is not allowed. So Francisco, if you are connected,
allow me. Only the organizers must.
Yeah, I'm not an organizer. Francisco is the only organizer.
Yes,
Could you please allow me?
Well, I'll try to put my copy.
I'm going to send you because I have. Oh, sorry. I'm going to send to you because it's a more.
So.
I'm going to send to you because it's a new. Sorry, 1 minute. 1 minute. So I'm going to. It's because I thought
Yeah. You have your presentation on the screen.
But this is so.
It's my copy, so.
Yes, do not worry. It's because I'm going to send to you the new one. I think you have the new one. If not, there is no problem. It is possible to send the last one. Sorry, 1 minute, because it's so long. Oh, but if not, I start. Do not worry. Sorry for the time. So the topic I'm going to address is the guardianship system for children without parental care in the European Union. Relevance for the objective of eradicating trafficking. So do you have here? You have. Oh, it's not possible to.
No, we can use this copy. Tell me when I have to pass the page, and we can use this.
So I talked, so you pass. You pass when you
yes.
See. I thought it is possible to pass because I'm going to be quickly.
Yes.
Quick. I'm going to speed up. So you have this. This is a brief outline of what I'm going to talk. So pass. So because we have faced a group of especially vulnerable people because it is obvious we have a migrant, a minor, and a company. And so as the definition, we must start with the definition for an accompanied minor, but you can see that the different member state uses different term and different definition. But I have chosen the definition of the directive. So you pass every because I have a lot of slides. So I have chosen the definition of this directive 2011. In this directive related for people who apply for international protection measure. So it is a children, a minor, who arrives on the territory of the member state and accompanied by an adult responsible, but also it includes a minor who is left unaccompanied after he has entered into the territory. So we can see that this definition can include both not only the third country national, but even this person, this minor who is in one member state and goes to another member state. So after this definition, there are some authoritative scholars that establish that it's more convenient to use the term separate child because it defines better the cessation problem of this child. So the another slide. So in this introduction, I'm going to offer you I'm going to offer you the social reality. Pass the slide. Sorry. So this is the term of guardian. While European Union recognizes the importance of guardianship, it does not define the notion of guardian. But again, every single member state uses a different term. I will explain later. So pass the slide. So related to the social reality of that, it is evident that the reality of migration of this minor has increased a lot, and the European Union is one of the main destinations. And see, it's because there is, as a consequence of there is a bad regulation of that, the principle of the best interest of the child, okay, is violated, and also it is the violation of a lot of fundamental rights. I don't know, I'm going past the slide because I would like to offer you a little example of this violation. I don't know if you're familiar with that. It's in a little village between Italy and France, where where a lot of minor and accompanied minor were returned full to France in violation of French, European, and international regulation, because it exists a very important principle, the absolute prohibition on refoulement in one directive. I will explain later. Pass the slide. And so only to give you some figure, in 1918, we have more than 30,000 applications, minor abandoned in all the European Union, and the highest number of this minor has been registered in Italy. Pass the slide. But after 5 years, in 2022, you have seen that this number has amounted to more than 4,000. So pass the slide. So we can see that you have here the country of origin in 2020. In 2022, this is the country that received. This is the country of origin. Sorry, in the another slide, and this is the country that received the highest percentage of minor abandon. It's not Italy now, it's Austria, Bulgaria, Cyprus, France, and Netherlands. Pass the slide. So in this slide, you can see the both information. So all in all, pass the slide, in order to offer you some novelties, there has been an increase of the proportion of girls. Pass the slide, but this is not, I think it's not the reality. The problem is that this migration is becoming visible, but because there are other problems, okay, hidden. And so pass the slide. So there is also a new pattern. There are another new pattern of unaccompanied children, but of course, all that's it is the consequence of the war. The unaccompanied minor for Ukrainian. Pass the slide. And so, all in all, in conclusion, according to that, the only data available we have in Europe is the unaccompanied minor who apply for international protection measure, like asylum, refugee, subsidiary protection, or temporary residence for humanitarian reason. But the remaining are not available. So the number I have offered you is only official number. The reality is much more higher. With this slide, I would like to offer you that we are faced a very sensitive issue under a political pressure. Pass the slide. And so, and pass the slide. So this is the key policies area falling within the competence of the European Union. So now we are ready to ask ourselves, what do international, regional, and European law require? Because is there mandatory law, non-mandatory law? We are going to see. Pass the slide. So it is necessary to be aware of that. So pass the slide. So we are going past 3 or more, because I'm going to focus on the European Union, because apart from the international human rights law and the European United Nations Convention right that establish mainly that the principle that the previous professor has established, that the best interests of the child have primacy of other aspects of policy involved. Pass the slide. But all these United Nations, okay, I'm going to pass, please. I'm going to focus on the Council of Europe. All of this does not regulate specifically the problem of the abandoned minors. So I will move on to the European Union law. Sorry, pass the slide. And so it is worth noting that it's very important. There is still no international unifying binding normative text exclusively aimed at the protection of this minor. And so pass the slide. The only binding European law that regulates this phenomenon is the so-called common European asylum system. Pass the slide. And so I'm going to focus only, so in this directive, within this system, I would like you to know only the differences between this term: authority, guardianship, the guardian, the legal representative, and counselor. Every single member state uses different terms. The most important is this, okay, the guardian authority. So because perhaps I will not have enough time, I'm going to explain now. The guardian authority is very important, that this guardian authority be independent for the migration authority. And the member state is divided in two groups. There are one group, we will say later, that are not independent, and also another are independent for this authority. And so mainly this authority is responsible for the guardianships and is made out of, be an integral part of the national or regional child protection system. But also we have the guardian apart, because I will explain later, but also apart for act on behalf of the minor, safeguarding the best interests of the child, must be a link between this person and this person. The guardian must ensure that this minor have a legal representative only related to the directing asylum. So this person is going to act on behalf of the minor in order to apply for this international measure. And so a legal assistant is the person who do all related to the administrative or judicial authority. But so pass the slide. So this is the only we have not related with this system. So in the European Oriental Living, only 3 ideas. The first idea is that I'm going to refer the Charters of Fundamental Rights of the European Union, because it's very important, because this right has a potential direct effect. But the wording of the Article 24, it's very, I think, it's problematic, because it is said the child's best interest must be a primary consideration, not the primary or the paramount consideration. So this principle remains open to divergent interpretation. Pass the slide. But to this slide and another slide and another slide is because I'm going to focus past the slide. So because we have directive, but the only directive more important is the qualification, the procedure directive, it's return directive. Because in this case, okay, we have a mandatory rule. It is said that the minor must have a representative and must be appointed as soon as possible. This is mandatory, because another one is going to be soft law. But no representative, this is the problem, should be appointed if the migrant will reach the age of 18 before a fair instance decision is taken. It is tricky. Why? Because the majority highest percentage of minor is between 16 and 18. So it is very likely that this minor, okay, become adults, turn 16 years old, because before a first judgment is rendered. It is an injustice. So pass the slide. So the other directive is the return directive. Remember the case of Vitimiglia, the little village between Italy and France. I'm going to explain that the return directive established another. We have very few mandatory rules, but this is another mandatory rule, the Article 5, the non-refoulement of the abandoned minor. But in this case, this directive has been transposed into French law somehow allow for some foreign refoulement, but some requirement must be met. 2 requirements. One of them established that must be assigned a legal guardian, and this must be executed for 20 hours after their detention. But in this case that took place in 2015, for instance, I have put this case that illustrates that, the case of the 12 years old Eritrean boy was returned, refused without these guarantees. So in this case, the judge imposed on French police the obligation to assign the minor a legal guardian and to inform him that he would have been able to apply for international protection. Pass the slide. So all in all, when it is true that the scope of application is limited only to an accompanied minor, as today member states apply for analogy, applying this general principle pending a more specific normative text. Pass the slide. So, because in conclusion, pass the slide. So in conclusion, I think that we have this, particularly chaotic European legal framework. The only thing we have is soft law instrument, a very little binding. So this scenario needs to predispose, I think, a specific European system of protection on accompanied minor, a system suited to respond to demands posed by their own vulnerability. Pass the slide. And so it's because I will move on to what our domestic says, because in the absence of that, national legislators themselves are called upon, are summoned to regulate decisions, normally in civil law, specifically family law. Pass law. And it's because in the second part, I will talk what domestic law requires, but previously I'm going to talk about only 3 problems, because there are a lot, but I'm going to select only 3 problems. Problems to be tackled that are common and share every single member state. 8 disputes. Pass the slide. It is very important. If the minor is not a minor, is not entitled to receive protection. So we have only one binding criteria in this directive 2013 on common procedure only. You know that the only binding test is related to the international protection. So 2 criteria. First of all, the only case in which the member states are allowed to use medical examination is when they have the member state or the official, for instance, the public prosecutor, have doubts concerning the applicant date. For instance, when this minor has no document, the document is presumed not to be valid, etc. So only in this case they are allowed to use this medical examination. But in the Saudi, in the less invasive examination by qualified medical professional. But if second criteria, if doubt remains, these scenarios go by the principle of in dubio pro minori, presumption of minority principle. Pass the slide. And so in this case, pass the slide, because the Commission denounces that the member state does not comply with it. Also, soft law. Pass the slide, because it's a recommendation, but it's not binding. So it's a good news that some good practices are increasingly being used in some member states accordingly to the international law. For instance, in Spain, there is the so-called holistic system, because the member state mustn't rely only on the medical test and must use a broader factor, hearing of the minor, also psychological report, another, pass the slide. So this is a good point, a good news. But to conclusion, in the first problem, there is a freedom to apply. This is a chaotic, because there is a freedom to apply system of assessment in each country. There is a lack of coordination, and you can deduce a serious consequences, because if in Spain this minor has the minor status, but in Italy or in France has the status of adult, this decision may justify the execution for return and also undermine the principle of mutual trust between member states. Pass the slide. And so as a consequence of that, so this is the first problem. So the second problem is that I have told you that an accompanied minor, only the accompanied minor who apply for international protection perhaps are more protected. Why? Because we have a directive, a binding directive, but the remaining unaccompanied minor has nothing. And so perhaps they are left on their own. Pass the slide. So this is another problem we have only. And also, however, it could be tricky, because even within the minor who apply for international protection, for instance, but the majority of time they are not informed of that. So this is not so likely, but okay, they apply for that. But in Germany, Austria, in Greece, their own status established. Oh, okay, if you have 16 years old, 14 years old, you are capable to act on your own. So you are not entitled to have a representative. So it is open to criticisms. It's obvious. Nevertheless, despite that, member states should appoint a guardian. Pass the slide. And so, okay, pass the slide. I'm going to select only some problems. And so this is very important. The lack of collaboration between the guardianship authority, including the representatives. There is no mechanism of exchange information. There is no common database on children. And also it's the other way around, because in this case, the only application we have is so-called Minila, that allows a minor, for instance, in Spain, to select the authority competent and to go to contact with the competent protection authority. But the system works in an inverse and perverse way, because it's the human themselves who seek protection and not the state who offer protection. So I think the solution comes to the centralized European database. Pass the slide. And so I pass the slide because I have, so we have seen, this is a case, this is a very insightful case study. I encourage you to read because it is explain all this problem I have talked about. Pass the slide. So with this problem, so I'm going to summarize, okay, what the majority of the member states established in the, but we can deduce that there are a different implementation of system for protection of accompanied minor. Pass the slide. And so, pass the slide. Because we can see this shortcoming, disadvantages and recommendation. Some recommendation to overcome this shortcoming that has the majority of the member states. Most member states have simply transferred their own legal institution for guardianship for national minor, abandoned minor or in distress to this group of children who has a specific vulnerability. There is no training. So it is this guardian entity or natural person are incapable of dealing with the specific issue, the slowness in assigning a guardian, and lack of trustings. And so in order to overcome this, we must, it is necessary the professionalization. It is why, because I'm going to finish with Italian model in 2017. So it is necessary the urgent and rapid procedure to be okay to all, and also the intimate relationships, because we are going to see that it's very likely that this minor went missing for the case certain. And so if there is intimate relationship, it's going to be easier to have effective monitoring of children throughout the European Union, preventing the child's impulse to suddenly leave the care. Pass the slide. And so if you, this is outline, pass the slide. And so very quickly, so thank you so much. The majority of the member states is well known that could be either an entity or a natural person. Only in Poland, okay, only the natural person can be tutor, okay, but in the remaining member state could be an entity, but in almost 1 out of 3 of the member states, Bulgaria, Cyprus, Hungary, okay, all of that, when an institution is appointing as a guardianship is specifically assigned to the director legal representative. For instance, in Spain, it is the social welfare delegate in the province of the community's autonomous administration. But I would like to highlight that normally the decision of these directives is taken in coordination with the technical team assigned. Pass the slide. So it is possible an entity, of course, the natural person could be, it is relative, professional, and volunteer guardian that has been enshrined in this law, very innovative law in Italy, also in Denmark, Sweden. And for me, it's a very good option because the minor needs a reference, needs a benchmark. Pass the slide. And so very important because we have seen the independence. Remember, I have told you, for me, it's a very important point because the member state must put a firewall between the protection of this minor and all the problems related to the flow of migratorians, okay, interest. So the independence, we have 2 groups of countries, Belgium, Finland, and another. In this case, the abandoned minor goes, okay, falls to Ministry of Justice, whereas the National Children Deprived is regulated under the Child Protection Services. So this is, okay, this is a discrimination. By contrast, I think this is the good option. Denmark, Spain, Netherlands, okay, both an accompanied minor, a national minor are falls with, okay, the children's service, okay, protection. Qualified, okay, the majority of member states establish a very general qualification and only in a negative manner, okay, through vetting procedure, pass the slide, and vary a lot between one member to other. Very important. There is no adequate training because very, very lot. Latvia is a very good example because this is mandatory and establish the content, the length, content of frequency, but there is no supervision and support. We have only this. This is the only 4 member states that offer this training. The training is also induction, introductory, but it's not always mandatory. Pass the slide. So I finish with the task of the guardian. The only binding rules about that came from the qualification directive. Say, okay, this minority need a representative, and the member state shall ensure the place either in a family foster or in a center specialized. You know, that's past the slide. Okay, it's the only article we have. But okay, but the most common task of the member state is, of course, the legal representation. I have no time, but it is well known for all. Only this country, Croatia, Italy, Poland. Okay, as you know, a guardian's authority to make decision, the most important decision, because it's not the custody, on behalf of the child, okay, have to seek an exchange approval of the court or other guardianship authority. Pass the slide. And so, and pass this slide. The second task is ensure that the unaccompanied might receive care, accommodation, education, healthcare, and manage the self-financing. All of you know that it is okay. It is now that the guardian is not obliged to live with the minor. Okay, and also safeguard the best interest of the child. I think it's very laudable, but we are faced indeterminate concept, best interest of the child. That's Austria has okay, enshrined, okay, enumerating the civil code, some of the criteria. Pass the slide of that. So act on behalf of the child, ensure the care of that, and save the world that. But it's very important because another are traditional. This is okay, very specific for the unaccompanied minor. The guardian has a concrete role to play in family tracing and voluntary return. But I think that Belgium is the only state, as far as I know, that established that the guardians are responsible for finding durable solution for an unaccompanied minor. Why? But what is durable solution? Okay, this is, for instance, to share and say, okay, what is better for the child? To go to another country, to stay in the country where this minor was placed, or to return with the family. So it is necessary to establish this. Pass the slide. And so is also it is a task of the guardian, okay, to defend a minor or in all related when this minor has been subject of traffic human being. It is very likely that this occur. And so the only okay, the United Kingdom is not part of the European Union, but it has a very appealing practice. Pass the slide. And so, okay, this is an example of the chaotic. Every single member state has a term, a different function. Pass the slide. This is an outline. You can see all the differences. In conclusion, 2 problematic issues continue to put European country at touch. The absence of a single European procedure for the establishment of the minority status and the absence of a common mechanism to assign a specialist guardian. Pass the slide. And so, okay, this is only it is worth noting to tell you that this program, European Guardian Network, because it's very useful for exchange good practices and other relevant information. Pass the slide. And also it's offer a digital platform. Pass the slide. So it is very important that it is encouraging that there are these projects. In particular, I have no time to explain because I have had a comparative study between France and Spain, but I'm going to finish with the Italian system, and I will later talk about the problem of the vulnerability of this minor to be subject of human trafficking. So pass the slide. Pass the slide. Oh, pass the slide. Okay, this is in France. Okay, pass the slide. Pass, because I'm going only to explain the good practices in these two countries, because I don't know, I have 5 minutes or 3 minutes. Oh, sorry, pass the slide, because I don't know if I have. Pass the slide. Pass the slide. I have no time to explain. If you have some question for me, because pass the slide. Sorry. Okay. Pass the slide. I'm going to go to the good practices, because if not, shortcoming. This is all the shortcoming in practice in this country. Okay, pass the slide, and I will move on to the good practices and the Italy. So good practices in Spain. I think it's very important to state that the majority in the member state, in France, in Italy, in the majority of the member state has been aware of this problem. When this unaccompanied minor is under the protection of the states, okay, but this minor is going, once this minor turns 18 years old, she must leave, okay, this system, this protection system. And so the member state must ensure to prepare young people formerly under guardianships for independent living, okay, to the adulthood, to live outside. So it is very important, this program. And so in Spain, for instance, the modification of the organic law protection in 2015 established this, offered this from 2 years before they reach age of majority, once they have reached the age of majority. But with respect to foreigner minor, the majority of NGO established that there is a gap between theory and practice. So this is different, the national abandoned minor and the migrant abandoned minor. But in October in 2021, the regulation of the immigration law has been reformed, and it facilitates access to residence and work permit. It's very important to speed up this procedure, because sometimes it's not, okay, time saving. And so, as well as those for the minor and accompanied minor, as well as those who arrive as children but age out during the procedure, because the procedure is very slow. Pass the slide. And so the last good practice I want you to know, pass the slide, is that there has been created, no, the another, sorry, the previous one, sorry, the previous one, okay, sorry. A special section for unaccompanied minor has been created in the police force. And so in this case, they are obliged, it is mandatory to receive a specific training, okay, because the aim is that they are, okay, in charge to inform this group of minors of all the rights they have in Spain, and also the right that apply to possible victims of trafficking in human beings. And the result of this information will be recorded in training. Pass the slide. And I finished with the good practices, 3 good practices in France, for me very important. There has been a very innovative law in France, 7th February 2022, marks a turning point in the reception and support of this. And I'm going only to comment only this. The same as in Spain, the modification of law, social action, or family code, okay, the member state must ensure this transition to adulthood, but through the so-called Jones adult contract. Pass the slide. But there are also, but till 25 years old, till 25 in France, other inspirational safeguard, the provisional urgent exception. Okay, it is not like in Italy, like in Spain, that we have a provisional guardianship. And in this provisional guardianship is very important, because in this, it is the time to identify the minor, to establish, to assess the age, the determination minor. But in this case, France has created 2 months in a hotel, only to a period of respite. It's before any assessment, only to establish initial assessment of their health needs. So for me, it has been a good, I think it's very innovative. Pass the slide. But there are also another inspirational safeguard, for instance, the support the host family. These are not foster family. It's only, okay, they are family taking in the unaccompanied minor from time to time in their own home to integrate more easily. Is very important in order to face, okay, to overcome all the problems that this minor, are very likely to suffer. More appropriate care is very important. Dedicated accommodation facility for young girl. Okay, the increase in case of suspected trafficking, human trafficking, caring for motherhood children. Pass the slide. And also, pass the slide. And also, very important. Okay, I finished. So here you have, sorry, because in French, but here you have all the member states that offer, okay, this transition to the adulthood. Pass the slide. I finished with the Italian model. Could be useful? I think yes, because here we have Italian, okay, professor. I'm very proud to because you perhaps will know better than me. But the law currently in France is the 2017 provisional protection measure for accompanied foreigner minor. For me, it's very inspirational. Why? Insightful. Because 4 points. The first unified text in all the European countries. The first binding unified test on the matter. It implements a holistic and multidisciplinary procedure for the identification. We'll explain very briefly. It introduces the legal figure of the voluntary guardian. They are for free. Okay, it's because it doesn't, there are going to be a conflict of interest and insists of an absolute prohibition or refoulement return of minor. Pass the slide. Pass the slide. And so why? Because two ideas. Firstly, related to the identification and the age determination model of Italy. There are two phases, very important. The first phase is for a maximum of 30 days. In this case, in the very first 10 days, it is produced the so-called identification procedure. But once this minor steps foot enters the Italian territory, she is hosted in a first aid and reception center. Is very important. And during the very first 10 days, they had an interview, not only to say, okay, tell me, give me the document. Okay, if there are documents, no documents, but during this interview, the minor is invited to express his history. Okay, pass the slide. Once, only when this phase, okay, only when in this phase we have, okay, reasonable doubt of the identification of this minor, it is allowed, it takes place the age determination procedure, the second phase, while and only because in this case it will be necessary to establish the biological age through a procedure that contemplates the development of socio-sanitary technique, or not only the medical, it is the so-called holistic. I have talked previously. It is so important to take into account not only the physical data, but only psychological, the interview, the hearing of the minor, holistic method. And meanwhile, very important, Italy said, meanwhile, as long as the person has not given an age, it is presumed to be a minor. Pass the slide. And so we have here the multidisciplinary, okay, in 27 hours. I have talked of that previously, so, okay, because of the time, pass the slide. So they defend the holistic multidisciplinary approach. Pass the slide. And also very important, Italy established the right to appeal, unlike Spain and other states, that the decree of the public prosecutor is final. So there is some cons, pass the slide, because we have no time. Of course, always, all can be improved. But very important, the second criterion, innovative criterion, the voluntary guardianships. We are hearing that there has been, Italy has, okay, give up a step further, because the Article 1 is entitled Establish the List of Voluntary Guardians. This is perhaps the most interesting novelty. It is mandatory to receive a training course, okay, in order to be, for these guardianships to be a guardian, because previously the measure of the municipality was the guardian, it was inviolable. So this measure was very well received, because in April 2018, more than 3,000 Italian citizens has already expressed their willingness to assume this type. But as long as the minor has not been assigned a guardian, establishes that, very important, the host, the resident, okay, establishes that the application for a residence permit, it is obliged in Italy like in Spain, not in France. Okay, the international protection can be submitted by the host structure. Pass the slide. And so in this, you know, this guardian represents a minor, okay, when is evidence, has the duty to apply for the minor residence permit, only may freely carry out, not all patrimonial acts, only the ordinary administration, and must register the minor with the national health system. Pass the slide. And so some uncertainties for me. I don't know if I'm in an error, but I think that there are these uncertainties related to the legal responsibility in the face of the disobedience of human. Why? Because there is a very important recurrent problem with this accompanied minor. And this accompanied minor went missing, disappeared, and the administration, okay, do nothing. Okay, unlike a father, if the minor disappear, react. In this case, okay, or different from the one established for the civil court for the national abandoned minor. In this case, the tutor can summon, okay, call upon the minor through the guardianship judge and, okay, call the minor. And so, but in this case, it is enough for the accompanied minor to leave the reception center for voluntary guardianship, to give up, waive, leave their burden or representation. And I think this is a problem for my, okay, but of course, pass the slide. It is, so this is a testimony of a minor and has, okay, caught my attention. To have a guardian as a reference is really different from living in a reception center. Okay, I think they can establish an intimate relationship so necessary. Pass the slide. And so I finished this intervention with, okay, this is, I would like to refer the Europon project, because it's very important, because it is the result of work carried out by French, Spanish, Italian, Swedish experts, and it highlights sparring practices and recommendations. Pass the slide. And we have passed the slide. And pass the slide, because these recommendations have talked about them. So I finish with 2 slides or 3 only, with the vulnerability of an accompanied minor, the human trafficking. Pass the slide. For me, it's very important, this part. Why? Because of their vulnerability, this human, it is evident, there are figures. Okay, this minor are more likely to be victim of this crime for different purposes: sexual exploitation, domestic servitude, coercion to commit crimes. And so sometimes this organized crime, this network, recruits them directly in the vicinity of children social work home. So it is, hopefully, no member state has developed a separate guardianship system exclusively for child victims of trafficking. Nevertheless, in the United Kingdom, okay, have been developed one. Pass the slide, because United Kingdom is a reference in this topic. Some data. Okay, nearly a quarter of all victims of trafficking, according to the European Strategy of Combating Trafficking Human Beings, nearly a quarter of all victims of trafficking are children, the majority for sexual exploitation. And it is said that the 9% are accompanying minor. Pass the slide. This is only some figure. And also you have here some pieces of news related that traffic and accompanying children are 3 times more likely to go missing than other. And so pass the slide. So we have this problem, and this problem do not okay, resolve the problem of the age determination, and not put a firewall between the protection of this minor and the migration interest. It is a factor that prevents this minor from not being subject of trafficking. Okay, the definition of the human trafficking is established in the United Nations Convention against Transnational Crime. This is the transport of people, or very, very quickly, the transport of people for the purpose of exploitation through coercion, fraud, abuse of power, vulnerability. But it's very important. The European Court of Human Rights has stated that the position of vulnerability is presumed to be, okay, if we are faced a minor, when it comes down to a minor, the vulnerability is presumed. And if this minor has been transported, not only has not international nature, to another country or within the country, we are faced this crime. And so it is very important. It's not said, but I would like you to know that the European Court, the Tribunal of the European Human Rights Court, has established that, I don't know, in 2013, that every single human being person who is subject of human trafficking, including the minor, has the right to receive the subsidiary international protection. Very important, not asylum or refugee, but subsidiary. Pass the slide. It's very important. These 2 rights that has been recognized by the European this tribunal. So I finish. This is my opinion, but it's not. It is not law. But for me, I think a guardian has a very important role in the identification, informal identification of this victim. Why? Because it is said that, okay, only when this victim has been identified by the state member with reasonable ground, this victim is going to have to be entitled to receive reparation, restitution, to receive psychological aid, whatever, indemnization, all the free legal aid. Okay, but so it is the fact that only formally identified victims of trafficking are entitled poses serious limitation. Only a limited number of victims are detected. But in some member states, there has been a modification in Spain. Okay, for instance, like in Spain. In Spain, in 2022, it has sent the NGO, the person who has a more intimate relationship with the victim, has the right to are entitled to do an informal identification. And once there is this informal identification, these minors are going to be entitled to receive the first aid, okay, to receive social services, psychology support, free legal aid, etc. And so I think the guardian can help to identify informally the victim. Pass the slide. I finish. Pass the slide. And also the guardian has a very important role to find durable solution. Only in Belgium and United Kingdom, the member state, the statute established that the guardian are obliged to establish durable solution. Okay, pass this. But the problem, what is the problem? Okay, the guardian has this duty, but there is no systematically specialist training for the guardian. The ONG offered training only in general, okay, on the topic of trafficking in general, without a particular focus on the role. For instance, in the pioneer preliminary draft in Spain on comprehensive organic law against trafficking in 2023 in Spain, the Article 15 states that a guardian or legal representative shall be appointed to act on his or her behalf, but does not regulate the formation of the guardian. Pass the slide. So I finish with a final thought. Oh, okay, sorry, this is, I would like you to know this thing is based on a real event. I encourage you to watch. Okay, this is Sound of Freedom. So pass the slide. And so some final thought, pass the slide. And so, first of all, there are great disparity between the types of guardianship. Okay, it is evident, provided children in the member state. Difference concern the appointment of procedure, timeline, profile, qualification, and tasks. There's a lack of coordination, but there is a common point. The slow, a canvas procedure through which the United is assigned a responsible guardian. It is, for instance, in France or in another country, okay, a 16th boy, a boy who is 16, when the procedure has finished, this minor has turned 18 years old. Pass the slide. So at the end, this person is not going to be protected. Second, in member state migration and asylum, law provision prevail over welfare. It is tricky, this Article 24 of the treaty, the Charter of Fundamental Rights, European Union. Okay, it is not, it is injustice. So third, to provide for the needs of the most vulnerable group of children, such as victims of trafficking human beings, harmonize and strengthen guardianship system, it's necessary, it's indispensable. Pass the slide. And very important, the lack of collaboration and cooperation between national authority, even the representative, prevent effective homogeneous monitoring of this minor throughout European. So there is a risk, okay, because it is a violation of the prohibition of non-refoulement. We have a directive, okay, but I think it is, we can overcome this problem with the implementation of a common database could be considered, but it is a question for you. This could imply the undermining of other fundamental rights, trying for the protection of every human right, with the right to the private family? I think not, but okay, in the article, I pass the slide. And so the issue is of concern to all national European institutes, a challenge to which our society must respond with solidarity and based principally on the international human rights commitment. Okay, pass the slide. But I think we must give one step further. Okay, given the principle that my previous the previous professor has spoken, the right to free movement between all the member states. I think the response should come from an initiative of the European Commission itself, as there is a need for an homogeneous regulation that harmonizes the national legislation currently in force. And I think that perhaps with some sense of cost, the European Union is moving closer and closer to the need for a harmonized regulatory development that's promoted cooperation between member states. In this way, the protection, could cease to be a pending challenge and could become a goal that has been achieved. So thank you so much for listening. I think children and adolescents are not only the future, but the present of humanity. Thank you so much. Sorry, because if I have no respect all the time.
Thank you very much, Dolores, for this very interesting and focused presentation. And I now immediately give the floor to the next speaker because we are running late. The next speaker is Giovanna D'Alfonso, who is professor of private law at the University of Campania, Naples. She will speak about children's access to the web between parental control and public protection interventions. Please, Giovanna, yes. The floor is yours.
Thank you. Thank you so much. Good morning to everyone. First of all, I would like to thank Professor Francisco Javier Jiménez Muñoz, la professoressa Elena Bargelli, la professoressa Ilaria Pretelli for the very welcome invitation. I feel honored to deliver my talk at this prestigious venue. My presentation. No. Okay. Yes. Sorry. My presentation starts from the consideration that although the access to the new digital means of communication can be an opportunity for development of the human personality of minors, the latter are not particularly vulnerable in the digital environment, since although technological adept at using the media, they are less aware or unaware than adults of the risk linked to the new technologies and of the rules established to protect their rights. Well, the European legislator has regulated the conditions of network access for minors in the legislation regulating digital consent. More precisely, Article 8 GDPR is defined the minimum age for the recognition of digital capability, providing with reference to the provision of information society service to minors that the processing of personal data of minors is lawful when they are at least 16 years old. Article 8 leaves open the possibility for member states to reduce this age by law up to the minimum age of 13. This option has been accepted both by the Italian legislator and Spanish legislator, which have lowered the minimum threshold for expressing the so-called digital consent to 14 years old. Below this level, it is provided that the consent to the processing of personal data is given by the person exercising parental responsibility. Article 8, paragraph 2 GDPR states that the controller should make reasonable efforts to verify in such cases that consent is given or authorized by the holder of parental responsibility over the child, taking into consideration available technology. Nevertheless, it does not indicate the methods for verifying age, which is still an open problem, especially with regard to the registration of social networks, since the relevant platforms do not in fact carry out any verification activity. The need to enhance the protection of the child has induced European legislator and those of the member states, when transposing the regulation, to specify that the language used by the data controller when collecting the child consent must be clear and simple, concise and exhaustive, easily accessible and comprehensible by the child, in order to make the consent given by the child and the information and communication relating to the processing concerning the child meaningful. The GDPR, in addition to regulating digital content, states that the general contractual provisions of the member states on the validity, formation, and enforceability of the contract concluded by the child are unaffected. If we want to investigate the ratio of such discipline, it can be said that the choice of the European legislator to set the minimum age for expressing one's digital consent at 16 and of some European legislators, such as the Italian and Spanish at 14, is an expression of systematic consistency with the current regulatory context, firstly international and then of national law, which has gradually allowed the right to self-determination of the minor of age, who is capable of discerning, to emerge in the exercise of fundamental freedoms also recognized on the web, such as freedom of thinking and expression, freedom of accession and peaceful assembly with one's peers, the right to access information, the right to engage in play, and recreational activities appropriate to one's age. The child right to self-determination was officially recognized at the international level by the 1989 UN Convention on the Rights of the Child and Adolescent, which, among other things, established the principle of the so-called best interests of the child and formalized for the first time the right of the child, which is capable of discernment, to freely express his or her opinion on matters that concern him or her, as well as the right to be heard. The principle of the best interest of child was then confirmed and made effective in 1996 Strasbourg Convention on the exercise of children's rights and was reaffirmed by the Article 24 on the Charter of Fundamental Rights of the European Union. One can well understand that there has been a real cultural revolution in the way of understanding the child. There has been a transition from an essentially paternalistic perspective that considered the child as an undifferentiated object of protection, since he or she was incapable of managing and taking care of his or her interests, and as such subject to parental authority, to the recognition of the child as an active interlocutor of the parent, of the dignity of an autonomous person, of the capacity to self-determinate in the choices that prove functional to the expression of his or her human personality, if he or she has reached the capacity of discernment. The child's right to self-determination, recognized internationally, has been validated in our legal system as part of the 2013 Riforma della Filiazione, as well in Spain by the Ley 2015 de Modificación del Sistema de Protección a la Infancia y a la Adolescencia, which amended Article 154 of the Spanish Civil Code. The reforms introduced a new regulation of parental authority, introducing the different locution parental responsibility in the respective civil code. The difference is not merely terminological, since the latter notion is the one that best defines the content of the parental duty, which can no longer be considered as parental authority over the minor child, but as an assumption of responsibility by the parents towards the child. These legislations generalized in their respective legal system the principle of the direct participation of the child, capable of discernment in all matters and procedures concerning him, her, proclaiming the child's right to be heard and to express his, her opinion. Article 315 bis, our Italian Civil Code, and 154 Spanish Civil Code. In the new legal framework, both Italian and Spanish, the personal identity of the child assumes a central role, since parents must take into account in a vision aimed at realizing the best interest of child. Nevertheless, it must be emphasized that although the recognition of a new form of digital capacity for so-called great minors gives them a greater autonomy, digital consent does not represent an adequate means of protection for a number of reasons, both because digital platforms often do not really verify the age of users, and because consent to be processing of personal data does not guarantee, in fact, the full informational self-determination of the minor, which is abstractly recognized by the legal system, since the indiscriminate collection of personal data and opacity of the processes of their collection and processing through the use of advanced technologies considerably diminishes the possibility for the person concerned to maintain control over his or her own data. And because consent to the processing of personal data, even if informed, is often not free, when there is in fact no real possibility of choice, since consent is imposed on the user as a condition of accessing the service offered. In any case, it must be emphasized that in the face of the loss of the central role of digital consent, the European legislator, with a view to ensuring a sustainable development of the infosphere, has adopted for an effective system of internal controls, providing that data controllers, as well as economic operators of information society service and automated processing, must take more rigorous use of compliant technology in order to prevent already at technical level prohibited conduct and to deprive potentially harmful technology of harmlessness. In this sense, the GDPR provides, by application of the accountability principle, that the data controller must adopt a series of technical and organizational measures for data security, and that he must conform data processing to the principles of privacy by design and privacy by default. Both the Digital Services Act and the Audiovisual and Media Service Directive 2018 are enacted with the declared aim of involving network players in the adoption of technical measures in the regulation to increase the security and content quality of cyberspace. Moreover, it should be noted that the main road to an effective and immediate protection of minors is represented by the precautionary powers attributed to the guarantor authorities operating in the digital context, with the function of preventing unlawful conduct on the web and the aggravation of harm to users. There have been numerous interventions by the authorities in Italy. Consider the intervention of privacy guarantor, who applied as a precautionary measure the interdictory power of self-protection under Article 58 GDPR, paragraph 2, letter J, ordering the suspension of data flows to a recipient in a third country, not respecting the discipline dictated by the GDPR. Our famous decision include taken in 2021 against the Chinese platform TikTok, and the one in 2023 against the USA company OpenAI, which developed the chatbot GPT. Having noted the importance of public intervention to protect minors, the purpose of my presentation is to highlight the centrality of parents' role of protection and control over the activity carried out by minors in the digital environment. It is clear that the first actors called upon to perform the function of controlling and protecting, as well as educating minors, are the parents. They share the duty to educate, instruct, and care the children within the framework of dialectical relationship that favors their increasing autonomy. And it is clear that the right of care and assistance for children goes far behind traditional obligation and must be enriched in the digital dimension. Moreover, if on the one hand, in front of child capable of discernment, the duties, powers of supervision required by parental responsibility, we can truly place for his or her instances of freedom and autonomy, which presuppose respect for his or her private sphere. From another point of view, specific needs may lead to the re-exercise of parental powers, even to the point of determining interference in the personal sphere of the minor children in order to make it possible to perform the obligation incumbent on the parents in the latter's own interest. The exercise of parental control over children is of central importance in terms of parental liability. In the member states of the European Union, there are numerous court decisions defining parental liability for digital torts committed by so-called major minors. In Italy, when such torts are committed by imputable minors, adolescents usually, civilly liable under Article 2043 of the Civil Code, our courts have recognized the concurrent liability of the parents with whom the children live under Article 2048 of the Civil Code. The parents are jointly and severally liable with the child unless they prove that they could not have prevented the act. The hermeneutical direction follows the consolidated jurisprudential orientation, according to which if the minor commits an illicit act and causes damage, there will be a presumption of parental liability for culpa in vigilando and for culpa in educando, which can only be overridden by offering not so much the legislatively predetermined proof that they were unable to prevent the act, negative proof, but rather the positive proof that they complied with the mandatory duties as per Article 147 of the Civil Code. More precisely, this proof inevitably ends up very difficult to absolve when one considers that many courts deduce the inadequacy of the education given and supervision from the manner of the offense. By way of application, the behavior of adolescents who publish or diffuse videos or images of their peers without their consent, infringing the rights, whether in social networks or by using WhatsApp, is considered by case law to be demonstrative in re ipsa of an educational deficit. Part of the doctrine and jurisprudence asserts that, given the evidentiary difficulties that parents would have to face, one would end up configuring the liability under 2048 of the Civil Code in the same way as strict liability, in particular for typical risk to be ascribed to the parental position. A parental liability mechanism, both in relation to the presumption of culpa in vigilando or in educando, and in relation to the possibility of liberatory proof within very strict limits, is a choice common to the European countries closest to us, such as Germany, Spain, and France. In the Spanish legal system, in particular, in addition to the civil law provision in Article 19 and 3, there is Article 20 of the Penal Code, the combined provisions of which configure to all intents and purposes parental liability for torts committed by minors under their care or living with them, based on a presumption of culpa in vigilando, which can be overcome by proving that they have adopted all the diligence of a good father to prevent harm. This was confirmed by the Tribunal Supremo, which unequivocally clarified that for children under the age of 16, the level of diligence required of parents is even stricter, to the point of prefiguring strict liability sin culpa o por riesgo. Also in Austria, 13 and 9 BGB, and in Germany under 832 BGB, there is parental liability for the tort of the child unless she proves that she has complied with his Obsorge in Austria, duty of care, or Aufsichtspflicht, duty of supervision in Germany. According to the German courts, the parental liability regime becomes less strict with increasing age and a higher level of education actually achieved by the child. The position taken by the French legal system on this point is in line with the Italian one, both in a similar manner, then to emphasize in the case of damage the relationship between the person obliged to control the person who caused the damage and the person who suffered the damage. I refer to Article 2042 of the Civil Code, Française Civil Code. The jurisprudential development mentioned leads one to the question concerning the limits of the power of control that parents are authorized to exercise without risking violating the right to privacy of minors and third parties involved. If, with regard to a minor under the age of 14, the activation of system of a rigorous preventive control of risk is admissible and consequently the parent's responsibility for the failure to adopt the tools made available by the same technology seems admissible. On the other hand, it will seem that when dealing with an older minor, the parent's control must necessarily be exercised in full respect of the child privacy in accordance with the recognition of digital capacity by the GDPR. The question arises as to whether any violation of the child's privacy would even be liable to result in compensatory consequences for the parents, as well as significant consequences with regard to the exercise of parental responsibility, or whether it is necessary to differentiate according to the specific case and to allow an extension of the power of parental control when the child over the age of 14 has conduct that show a total or partial incapacity to manage his or her capacity. The question to be asked is therefore, on the basis of which parameters is the balance to be found between the two opposing needs, that of the child to self-determinate and freely develop his or her own digital identity without interferences in his or her sphere by his or her parents, and that of the parents to protect, supervise, and take care of obligations arising from the proper exercise of parental responsibility that might require access to the digital data of their children, even those over the age of 14, in order to protect them. In Spanish jurisprudence, there are many pronouncements concerning the control measures that, in the exercise of parental responsibility, are taken by parents. We refer in particular to the installation of control application in terminals, such as mobile phones or tablets of minors, in order to obtain information on the activity they carry out, to parental access to the child's social network site without the child's consent, and to parental supervision on the child's WhatsApp. The prevailing hermeneutical orientation argues that, although such parental control tools clearly interfere with the child's right to privacy, nevertheless, in some cases, another interest equally worthy of protection converge the parent derecho deber de protección. Article 154 Civil Code, Spanish Civil Code. Below this jurisprudential orientation, the legal system cannot impose on parents an obligation to protect their children without admitting the means to perform it, and therefore deprive them of the possibility of adopting such means of control whenever there are objective elements suggesting the existence of danger. In such a case, in the opinion of the court, the presence of the higher legal interest of the protecting the child that the parent intends to realize must prevail. Obviously, the control measure, on the one hand, must respect the degree of the maturity of the child, and on the other hand, must be proportionate and reasonable given the infringement of the child's privacy. In conclusion, one agrees then with the hermeneutic orientation of the Italian courts, I think Court of Caltanissetta, Parma 2022, which, following a new consolidated orientation of our Corte di Cassazione, sustained that the proper exercise of parental responsibility may, in certain cases, must require more strict control, which may therefore also include access to the child's digital data, provided that it proves that to be necessary and proportionate to the specific needs, always having regard to the age and degree of maturity of the children, and is carried out in a manner that always takes into account and respects the identity and dignity of the child, and therefore it's not carried out in an unmotivated, sudden, and clandestine manner. Thank you for your attention.
Thank you very much. Very helpful. You are the last speaker of the first session, and now a Q&A session is going to start. accordingly, I invite anyone who would like to raise questions to the speakers to raise his or her hand and simply show up if there is any question. Well, if there is no question, I would like to ask something to Virginia Zambrano regarding the withdrawal of consent in case of artificial procreation. I don't know whether she's still here. Yeah.
Yes.
Well,
Virginia?
yes.
Yes, it's okay. Okay.
Yes.
Yes, okay.
Well, I would like to know your opinion or your feeling about the recent judgment of the Italian Constitutional Court.
Well, that's I was, when I read the judgment, I tell you, I was wondering what would have been my opinion on this topic. I tell you, at the age of the law on of 2004 on medical assisted reproduction, you know, my opinion at the time was that I mean, it's a question that you can withdraw your consent. You can withdraw your consent because it's a question of your it's a question of responsibility. You know, if you don't feel like growing up or assuming the responsibility of a child, then you should have the possibility of get rid of that. I don't find, I tell you, any difference between a natural birth, no, of a child born after a natural relation, no, with the father that lives and abandons the wife, and there is really no difference, no true difference. For sure, it's a question of economic and patrimonial responsibility, that's for sure. But this is something else. I mean, you should be free of, you know, if you don't feel like anymore to be or to act as the father of, because I don't think it would be even not in the interest of the child, even in the interest of the child, to have a father that doesn't care of him, doesn't give him love, and doesn't pay attention to him, and so on, and so on, and so on. I know it's quite a very strong position, but that's my opinion. I mean,
I ask you just because you have a comparative knowledge,
perspective.
And
I know. I find, and you know, on top of that, I find it's you could, let me say, withdraw your consent up until the implantation, as it happens in France, as it happens in other countries, but not, I mean, 7 days. It seems to me like the law on the protection of consumers. You know, you have the right to rethink and so on, and so on, and so on. Such a short period of time, my God. And you know, in the case was that the question was that after a while the couple splitted, so that's was the reason.
They were separated,
and then the consent was not anymore a consent, a true consent, a actual consent, let me say, an actual consent. I mean, if we compare what happens in the normal relation with what happens in case of assisted reproduction, here once again, and go back to my speech, we have the proof that the legal system are threatening in front of the use of private autonomy in the family relation. And what they do, I won't be like Foucault, no, but I won't follow the Foucault approach. But as soon as they realize that there is something that can escape from the control, they intervene. How? By forbidding all kind of maneuver on this situation. So that's it's not easy. I understand that there is still some, let me say, ethical background, but I mean, the ethic and moral is a question of personal choice, can be imposed from the top. You know, it's you have to behave in a way that you feel in line with your ethical behavior. This can be something that has been imposed by someone else or by kind of even worse, paternalistic approach. That's my opinion on this point. I know it's not easy. As I know it's not easy. On top of that, you know, there is the question of the best interest that sometimes is used as a shield. We use the best interest to avoid change, to avoid everything, because it's in the best interest of the children. I mean, what happens with the homosexual couples and surrogate motherhood is a clear example. I don't find it's against the best interest of the child to have or to have been born through the use of a surrogate techniques. Maybe the children are happy even though born, and sometimes, and we experience this kind of situation, there are natural born children that are absolutely unhappy within their family, even though they have a very natural, of course, parental link. So what is the point? It's the question that, you know, legal system, the state legal system, try to get into the relation, the family relation, because they have the fear of losing control.
Thank you very much.
You are welcome.
Thank you very much, really, Virginia. Is there any question or any remark?
Especially on this topic, I mean, I would like to know what your opinion or the other participant is like, because, you know, it's really an ardent point. It's quite something.
Yeah, it's a very hard point.
Yes.
Any question?
Everybody is happy with this. With
the judgment of the Constitutional Court, perhaps.
Yes, perhaps.
Well, perhaps I may ask something to Maria Dolores, and then Maria Dolores, you mentioned that about guardianship and minors, unaccompanied minors.
Right.
You mentioned that well, you
sorry.
In your presentation, at a certain point, you mention, or you hope, in a way, that this topic might be harmonized at European level. Is it just a hope to be pursued by soft law, or do you believe that there is any legal source, how to say, allowing such harmonization?
Thank you so much for the question. Sorry for my voice. I'm not as far as I know, in relation with regard to the question you have told me, I think that, okay, it is a hope that it is necessary, this harmonization, because you have seen this lack of harmonization. But I think there is a point very important. It's because, okay, it is the different interests of the member state related to the control flow, migratory flow. So this is the point. Always it is the same. And the Article 24 in the Charter of Fundamental Rights of the European Union, it is said, okay, the best interest is only the A, but not the paramount. Also, always in the member state, I think it's a hope, I think, but there are some, how do you say, problems or interest, another interest with a lot of strong, because it is an issue under a very political pressure. This is the migration. So even we are facing minor and unaccompanied minor, at the end, there are two approaches. One approach is the member state who say, okay, we have this, we are going to interpret this article in the sense that all the maker lawyer, all the political legislative is going to have a draft that is going to say, okay, these policies, okay, must, of the protection of the minor, must prevail over the migration interest, but there are another not. So there is not, Elena, that, thank you for the question, because I'm not a very expert. I'm working on it, but I think there is not a draft law in order to harmonize, but it is from the NGO, for a lot of organizations, it is very necessary, because, okay, there is perhaps one point. The European strategy for combating human trafficking, it is said in a very hardly way. Okay, it is necessary. It is one of the priority in the European Union now, okay, to combat the human trafficking, and combat the human trafficking in this group of minors, the accompanied minor. They are very likely to suffer that. So I think perhaps we have a hope in this line, because these two groups converge to that. It is necessary, because there are a lot of, because this is a lot of minor went missing. So it is very necessary to that. And so for the free movement principle that all of you have said, Elena, Roberta, all that the more authorized person who has talked previous to me, we have told the principle of free movement of people in Europe. And I think that the European Union is obliged to enact, okay, law to resolve this problem. I offer problem, but no solution. But I think we are on the way. We must be on the way. Sorry, I don't know if I have made myself clear or not.
Yes. Virginia?
No,
Please.
yes, it was very, very interesting, and I explain why I am very interested in this topic, because at the moment I am a member, a representative of the United Nations on Human Rights, and I work as member of the United Nations in the local commission for the permit, no?
Yeah.
So I know, because I am facing with this kind of problem every now and then. And you know what's the problem with, that's a very Italian situation, maybe
Yeah.
Elena would better, and Giovanna and the Italian colleague would better understand me what I am talking about.
Yeah.
Because we have a pre-Cutro pre-Cutro decree, and that was the Cutro was a decree, it was enacted by our legislator when the tragedy of the happens on the shores of the Sicily this year, and a post-Cutro decree. So it's the question is that right in the field of minor or of non-accompanied minor, the question is a strong, big struggle between what's the interest of minor is and what's the the concept and the enactment of public policy on the other side is. So that's the tension that now work in our legal system, And as far as this position is concerned, I do agree with you, Dolores, that we should have a common regulation, because a minor is a minor in France, in Spain, in Italy, in Greece, and so on and so on and so on. But on the other side, this general, very important principle has been challenged by the pressure of migration, which is, gives strength to the barrier of the public order, so that in the end, we finish in a very
it's very complex.
Yes, in a very complex. We end up in a very complex situation. Just to give you an idea, now non-accompanied minor in Italy, when they arrive in Italy, when they land on our coast, are conveyed in a unique big center with no differences between adults
and minor.
And minor,
This is prohibited.
This is, so those people, on top of that, I tell you even more. Of course, in theory, our legal system for minor or for non-accompanied minor is think of a special legal assistance, what we call tutore del minore non accompagnato. Yes. But they are not paid. They are not paid. So they are not I understand why they are not paid. I understand why they are not paid. But if you are not paid, you don't feel like assisting properly the child, the minor. So just like a cat that is biting the tail.
Thank you.
Thank you.
So
Thank
do
you.
think the new law it has not been so better, so good? But perhaps it's better than the mayor of the town. The mayor who's the responsible. Thank you so much. Thank you so much, because you know better.
Thank you. Then now we have, if there is no question or no further question, we have a break of perhaps 15 minutes, after which we have the second session, whose title is New Models of Family Law, and which will be chaired by my colleague Ilaria Pretelli, co-chair of the SIG. Please, I would like to remind you that after the end of this webinar, there will be a focus on new technologies and filiation this afternoon at 5:30 p.m. At the link we provided for through the ELI's platform. So now hi, ciao Ilaria, hi.
Hi.
So
Hi.
I would say 15 minutes, perhaps, as we are running late, or if you prefer, we keep the 20 minutes of break we
No,
planned.
15 minutes is fine. Yeah.
15 minutes. So you will be back here at 12:20, I would say, or 25. 20.
20.
Okay.
20.
So 12:20. See you later. And of course, the floor will be yours, Ilaria.